And also welcome to those of you who are online. This is this is a busy time of the semester, and we know that many people will appreciate the recording as a chance to return to this. I'm looking forward to a very interesting conversation in both this session and then following it after a brief break, another session with our other guest this afternoon around the question that generative AI poses for the legal structures and rights and practices of copyright in the United States and in fact around the world. And I think this conversation is designed to be informative, so there will be a little bit of just basic getting the community up to speed about the terms of the law. It's also designed to be thought-provoking, and we've invited one of our speakers to kind of provoke us into some thinking about what's at stake for authors and creatives as generative AI emerges as a technology. And then it's also designed to be specifically reflective for the MIT community and others who are interested in what's at stake at the interface of technology and society. So I will introduce our main speaker for this first session in a moment. Before I turn it over to him, I'm going to Umair Kazi, who's the Director of Policy and Advocacy at the Authors Guild. I'll give a longer introduction in a few minutes. I'll just say a little bit more about myself, about SERC, and then give you kind of maybe about 5-10 minute overview of the history and current status of copyright in 21st century United States. As Nico said, I'm a professor of history here at MIT, where I teach and publish in the field of 20th century US legal history. One of the courses I teach at MIT is called The History of the US Supreme Court. Although I am not a lawyer, I am a legal historian and also serve as one of the advisors for MIT's Haas concentration in legal studies. I should just sort of say, given everything that's going on in the world, in my teaching, I do teach about the rule of law, the separation of powers, the Administrative Procedures Act, the Impoundment Control Act of 1974, other things that I hadn't had on my syllabus last year, but will be adding to them very, very quickly. And it's really designed to be a space for MIT students to grapple with issues from the past as they connect with the present. In the last year or so, I've had a chance of doing this in conjunction sometimes with SERC, with Social, Ethical, and Responsibilities of Computing initiative of the college, which is, as it described itself, is facilitating the development of responsible habits of mind and action. And I love that phrase. For those who create and deploy computing technologies and fostering the creation of technologies in the public interest. And so I think it was a logical connection for us to think about generative AI and copyright as crucial issues, both for fostering the creation of technologies, thinking about the public interest, and also developing responsible habits of mind and action for technologists at MIT and beyond. So let's get into the kind of the nitty-gritty of it, I'm going to sort of run through some history for you here for a few minutes. I don't have slides, but I'm happy to provide citations or other information in the Q&A if people would like to know more. We certainly know from our founding documents some of the key phrases that we know pretty well. We know all about the pursuit of life, liberty, or we know about life, liberty, and the pursuit of happiness. We know from the Constitution and the Bill of Rights that property is protected from taking without due process of law. But one of the phrases that does not appear in the Constitution is the phrase intellectual property. The Constitution says that it uses this nowhere, but nevertheless, the Constitution is what protects intellectual property as a form of property in general. And where we can find this most clearly is in Article 1, Section 8. Article 1 gives Congress the power to do the following, quote, to promote the progress of science and useful arts by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. Right, so this is the kind of key phrase, that in order to promote the progress of science and useful arts, that Congress gives us the power to secure for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That brief phrase structures all of intellectual property law in the United States. It emerges from an Anglo-American tradition. There are, of course, versions in the EU and in other jurisdictions, which I do not have the expertise to talk about today. Now, this breaks down into two parts, right? So for inventors, there are patents. And again, this is not something that we'll be addressing today, but of course, intellectual property certainly extends to patent law and other fields. But for authors, there is something called copyright. And we'll focus on the latter here. Now, copyright, to give a basic definition, and I'm borrowing here from the US Copyright Office, which is an entity of the Library of Congress. Copyright protects original works of authorship as soon as a human author fixes the work in tangible form of expression. So you can't just have the idea, you have to fix the idea in a tangible form of expression. Now this takes many forms. This could include a book, but it could also include computational code, paintings and photographs, musical compositions, and the list goes on. Now, as we think about the implications of generative AI, it's worth considering maybe three more terms that you might want to have at your fingertips or that you might come across as you're reading in this area. But copyright law also spends a great deal of time considering the definition and the boundaries of what is called derivative works, such as translations, musical arrangements, movie adaptations. Right? New things that come from old things, right? That are derived from existing things. And derivative works can be copyrighted, but they can only be copyrighted if they are substantially transformed and if they bear the personality of the creator of that derivative work. Right? So, a translation of a book from Japanese into English can be copyrighted if it bears the personality of the creator of that derivative work. How I might translate a work is different from you, right? And that's in part what makes it derivative and also therefore copyrightable. Copyright also extends to the production of the second term here, transformative work. Right? And to understand what that means, courts have generally seen this as one that adds new expression, meaning or message to the original work, right? So it's not just a copy, right? But it is a transformation. Transformative work also does not substitute for the original use of the work. You can't use the one instead of the other as equivalents, then hasn't been transformed. And third, that it does not harm the market for the original work, right? So if there's something that claims to be a transformative work, but it essentially puts the original out of business, then the creator or author of that first work might have a copyright claim to make. All right, third term, and then we will dig into the specifics, is the term fair use. That the protections of copyright do allow for the fair use of copyrighted works. And this happens at MIT every day. As MIT faculty, you may use copyrighted images in class or share short readings for educational purposes to a limited group of students. Right? And this is, and there are general guidelines for fair use that courts have adjudicated. When they do, they use four principles to figure out whether something is a fair or an unfair use of a copyrighted work. First, the purpose of the use. Right? Is there a purpose to transform or duplicate something they would consider? They would look at the nature of the copyrighted work, at the initial copyrighted work, and whether it is highly creative or not. Third, the amount of the taking, right? Did you copy a portion of a book or photocopy the entire thing, right? The courts will consider that, something like that. And fourth, what is the effect on the market for the original? Right? Does a fair use of copyrighted material put the original out of business? So these are some terms Umair is going to talk about in his presentation about how this affects authors that he works with. Claire Schneider, after this, is going to talk about some of the implications of those for the MIT community. Let me just say one more thing, which is this question: what is copyright for? What were the founders aiming to do in the Constitution in 1787? And certainly they said very explicitly what they wanted to do. They wanted to promote the progress of science and useful arts. right? And that remains, I think, very important today, almost 2 centuries or more than 2 centuries later. The solution that they hit on in 1787 was the second part of that clause, right? To secure for limited times to authors and inventors the exclusive right to their respective writings and discoveries. It is not immediately clear that the solution that was offered in 1787 still works in an age of generative AI. Right? And I think that the founders would, really thought that fostering innovation and rewarding creators were two sides of the same coin, right? And that balancing test certainly remains important today. Some now feel that the claims of how this is at stake have changed from two directions. First, from publishers, who see a threat to their business model and who are asserting copyright claims against generative AI companies. You may have seen this line of argument in cases brought by, for example, the New York Times. And second, from authors who object that large language models are profiting from their work and are concerned that LLM outputs may threaten their professional livelihood. Now, over the course of the day, and of course in other programming we may do at the college over the course of the semester, we'll explore these issues and some of the implications that are at stake. But now what I'm going to do is turn things over to our guest, Umair. Umair Kazi, as I said, is the Director of Policy and Advocacy at the Authors Guild. This is a professional organization of over 15,000 writers. And in his capacity, he oversees the Guild's policy portfolio, including positions on copyright, collective bargaining, antitrust, and artificial intelligence. So he's a great person to talk with us today. He has previously served as the Guild's staff attorney and holds a JD from the University of Iowa College of Law, and also, importantly for the Authors Guild, an MFA in creative writing from Columbia University, and translates poetry from Urdu with work published in several literary journals, and has contributed a chapter on digital book piracy in the first edition of the Routledge Companion to Copyright and Creativity in the 21st Century. So Umair, the floor is yours.
Thanks everybody. Thanks, Chris, for that wonderful introduction and really great background on copyright law. It's I kind of fell into copyright sort of by happenstance. I didn't study copyright when I was in law school. I was going to go into finance law, and then the financial crisis happened. But when I was doing my MFA, I had the opportunity to start working for the Guild, who were looking for a lawyer at the time. And it's really one of the most fascinating areas of the law. I think it gets closest to philosophy at times, and the questions that we grapple with are so rich and just have deep implications for the way we interact, the way we communicate, what we read, how we browse the web, etc. So I'll just start by giving kind of a brief background of the Guild and what it is, what it does, and how we got involved in generative AI. And in that process, I will touch on some of the concepts that Chris introduced: fair use, transformative work, derivative works, etc. So the Authors Guild is the oldest and largest professional organization of writers in the U.S. It has been around since 1912. Right now, we have 15,000 members, all working authors, and we really focus on this idea of the professional author, which goes to our mission of providing and fostering an environment where anyone who wants to write can earn a sustainable living from their writing. And that's a big part of our mission. We're active. We are active in DC as a lobbying group. We lobby on behalf of authors. A lot of our work has been in copyright, but we also, given the way the publishing industry has changed and the income potential for authors has declined, we've sort of moved into other areas of the law, including antitrust. One of the initiatives that we have been working on is to give authors collective bargaining rights, collective action rights. because they're independent contractors under current labor laws. They can't work together, which means that one author cannot talk to another author about what they're getting in their contracts, and they can't all go to the publisher together and say, hey, this is unfair, these are the kind of terms that we want. So that's one of the things that we've been working on. But pretty much since late 2022, AI has kind of like been a daily presence in my life. Not a day goes by. I mean, it's just endless calls on AI. We've done a lot of work on AI in the last now almost 2 years. And what happened in late 2022 was ChatGPT came online, and we very quickly just to pause there for a second, and we actually were aware of implications of AI for copyright for like a few years before that, because we had seen prototypes like, I don't know if people have heard of the next Rembrandt. Now it sounds like Atari, but I think in 2018 or so, it was kind of like the state-of-the-art AI model, and it was AI that could developed by Microsoft that could generate images in the style of Rembrandt. So we were aware of the questions that AI raised for copyright. One of the questions, I'm glad you mentioned that in your definition of copyright, you mentioned human author, and that was actually a huge question at the time. It has to a large degree been resolved, but the question was, what happens when a machine creates a work of art, a work of literature, writing? Does the machine own copyright? Who owns copyright in that creation? And there is a long tradition in copyright law of recognizing that copyright only belongs to the human author. There's a long line of cases. The idea started really kind of becoming or getting fleshed out in the early 20th century with the advent of photography, where courts grappled with the question of whether or not there was any originality of expression in the work. And so the question of what is human authorship? Is it the machine that's creating, or is it the author or is it the human that's creating? Really became a focal point of early sort of copyright discussions around AI. In 2023, the Copyright Office came out with a guidance document that essentially talked about how it would register works that were created using AI, and they, following the long line of cases, they said that they would not register works that the author or anyone claiming registration in the work that had some AI use would have to disclaim the parts that they did not themselves create, that were not created by a human author. So that's where we're at right now. If you use Stable Diffusion or any number of image generating AI to make an image, unless you modify it in a certain way, that's not copyrightable. And even then, only the parts that are that have human authorship and original expression, only those parts are copyrightable. So, for example, you could have there was one interesting example that I heard recently where someone had created an artwork but only used like a dog that was generated by AI, and they were thinking about copywriting it. And the answer is, well, yeah, the Copyright Office will register the artwork, but you have to disclaim the dog. And the dog will not be. So anything that is generated by a machine is actually is not protected, so anyone else can use it without any need for any authorization. So that was one of the questions that we were grappling with. At the time, we weren't really aware of. There wasn't a whole lot that we were aware of as far as how training is done. And since then, the primary focus for us has been the ingestion of books and other copyrighted materials when it comes to training. When you train an LLM, you need all kinds of data, right? In computer science parlance, you just say data, but like this data also includes, in some cases, hundreds of thousands of books, and we know, in some cases, we know the models and the books that they were trained on. In other cases, we don't. Some of the models out there, some of the large language models are black box models like Anthropic and the GPT models after 3.5. So we don't really know the data composition, the training data composition in those cases. But we do know by analogy from what developers have told us. For instance, Llama used a data set called the Pile, which includes a sub-data set called Books 3, which is comprised of 200,000 books that were downloaded from a pirate site. So, and oddly enough, this was revealed by the developers of Meta in a paper they put out, where they got the data set. And so for us, that is a huge concern. If developers are going out there and instead of licensing the books, they are downloading pirated copies and then training large language models on them, that's ultimately one, it's unethical because, as in the definition that Chris mentioned of copyright, there's a key term called exclusive. So the exclusive right means that you, as the inventor, in the patent scenario, or you as the author or the artist, as the creator of that work, you can exclude anyone else from using that work. You decide who gets to use that work, on what terms, etc. And it's a limited monopoly that Congress created precisely to encourage innovation. When you download a book or download 200,000 books to train a model, you are infringing on the exclusive rights of the author. Now, there are legal nuances that I'll go into a little bit. Chris also mentioned the notion of fair use, which is a very key concept in copyright law, and that basically allows it's not a suspension of copyright, but it's essentially an excuse because courts understand that the copyright clause begins with the preface for the advancement of arts and sciences. So there is a public kind of good element in the copyright clause. And fair use facilitates that. Fair use says if there is something that is being innovated, then you can use a copyrighted work without permission. Now, there are the four factors: the amount and substantiality of the use, the nature of the copyrighted work, I always blank on the third factor. the effect on the potential market of the work. What is the third factor? Is it yes. So the amount of the taking. So it's essentially a balancing test, and courts, when they look at these questions, they're not supposed to give equal weight to any of the factors. So in some cases, the court might say, because so one example from a recent case. Supreme Court case was Andy Warhol did a screen print based on a photograph that was taken by a photographer. Now of Prince, the artist formerly known as Prince. Now the photographer licensed the Prince images on her own, and then Andy Warhol's silkscreen prints were competing in the same market as the photographers. The Supreme Court, when it looked at the four factors, it gave more weight, even though it found that the work was what is called transformative, that it added a new medium, meaning, or message to the original photo of Prince. It did so in a way that had a profound impact on the market for the work. So in that case, the court weighed the fourth factor a little heavily and came out and said this is actually not fair use, and this was actually infringement. So it's fair use is interesting. I'm not a litigator, but I've been around litigators who litigate fair use, and it's you never know. You never know how it's going to come out. You can be sure of your arguments, and when you go in, the court's looking at it in a certain way. But what's and this in the ongoing litigations. Now there are several ongoing litigations over AI, generative AI. There are litigations in image against Stable Diffusion, against Meta. Pretty much any company that develops AI is facing a lawsuit right now. There's also several. I believe by last count there were 13 lawsuits against large language models that were just brought by authors and publishers. They're all class action. Most of them are class action lawsuits. So that means that if and when the lawsuits progress, they could cover, thousands of people. But the key question that will come up in this lawsuits, and it hasn't come up yet because the defendants, the AI companies, haven't asserted a defense yet, is that they will say that I'm just trying to be mindful of time too. So okay, they will say that our use is actually fair use because we are transforming the work. We are transforming the work into something new, a new technology. Now the problem with that argument that we see, a big problem, is that these technologies are capable of, in many cases, actually reproducing the work. You can. We have filters now in a lot of the public-facing AIs, but we know from experimentation that in many cases the AI can reproduce verbatim the contents of what it has ingested. There have been experiments to show that people are working on these solutions all the time. There's also in other situations the AI can be prompted to produce a derivative work, for instance. Chris mentioned derivative works. One example of a derivative work is a very common example of a derivative work is a film adaptation or a screenplay based on a book, and you can easily use an AI to do that. So what I'm trying to get at is that the technology, even though there is something that's new happening to the work, conceivably, it is also a technology that that can completely eviscerate the market for the works, not just the works, but eviscerate the market for the rights in those works. So, if you can use AI to create a screenplay, that will diminish the value of the film rights in a book. If you can use AI to, in some cases, when we were when we were experimenting with GPT and trying to figure out what it could do from the perspective of an author or published work, one of the things that it can very easily do is, or other AIs can do, is create a hypothetical sequel to the work, which again is an exclusive derivative right that every author has under copyrights. I'll just I don't think you mentioned this, but basically, copyright itself is a bundle of 6 exclusive rights. The right to reproduce the work, the right to publicly perform the work, the right to create derivative works of the work, which is, you can use your work to create a new work or license it to somebody else. The right to distribute copies of the work, and there is one that's a specific mechanical right for media. The right to publicly display the work, and then the 6th right is a specific mechanical right. So these 6 rights together are what enable any publishing contract to come into existence. They enable any film rights deal to come into existence. The film rights deal is premised on the right to create a derivative work. A translation contract is premised on the right to create a derivative work. A publishing contract incorporates the right to display the work, the right to reproduce copies and distribute copies of the work. So the value of all of those rights, it's not just that the value of like a book will go down, that people will stop buying a book, but what will happen is that there will be the transactions that happen right now for authors and publishers, the value of those rights will go down. So that's a big concern for us. Let's see. There's so much that I can I can talk about, and don't want to go over time. Just looking at my notes, because I know that we will have things to talk about during the Q&A as well. So maybe I can mention some of the other things that we're doing because we see this challenge. And we really want to preserve the human writing profession because there's no underestimating it. AI is posing a pretty existential threat to this profession, and I'll talk a little bit more about in our Q&A. So we are active on several fronts. We are working with members of Congress to introduce legislation and regulations that will protect human authorship. The way we're trying to do it is, one is that we need to know what is being ingested by the models. I mean, I think there's an interest in this policy from a lot of different groups. Privacy groups are interested in that. We should be able to, as consumers, we should be able to know what's being put into the large language models or like other AI. The second thing that we are concerned about is the market harm to human created works, which is why we've been supportive of and pushing for disclosure requirements on AI generated images, text, and other types of content. And again, we can come at it from copyright, but the thing is the ramifications of AI, they really radiate into other spheres of our life. So for instance, disclosure, we are interested in it from the point of preserving a market, but there are other policy reasons for requiring disclosures. Non-consensual pornography is one of the ones that is very often cited as the biggest reason for there being a disclosure requirement, so people know that something is AI generated versus quote unquote real. We are also involved in a lawsuit right now against OpenAI and Microsoft. That is a class action lawsuit with 13 best-selling authors as the class plaintiffs. And all of the lawsuits, including ours, are premised on the simple allegation that in the course of creating large language models, developers made illegal copies of the works, full copies, because as we know, the training data set, it's in self-supervised training, you don't really break it down or annotate or anything. You just kind of throw all of the text that you can find in a large file and run algorithms on it. So, and that actually is a violation of one of the exclusive rights, which is the exclusive right to reproduce the work. So by making a copy to train a large language model, you're actually committing a copyright infringement violation against the author. So that's what the lawsuit is premised on. It's still in its early stages. In fact, like our CEO was in a deposition yesterday, so we'll see how things go from here. But the likely scenario is that fair use is going to play a pretty big role in the coming months, especially in this landscape. So I think I'll stop there, and maybe we can continue to Q&As, because I'm sure the audience might have some.
Absolutely. All right. Thank you. I think these are on. Yep, they're on. So before we get to the public Q&A, I'm going to just kick off with one or two questions for Umair for some things that we had been emailing about in the last few days and weeks and kind of leading up to this. And one is I wanted to just talk a little bit about what it would mean to the Authors Guild to win a case like this. And let me say more about what I mean. That the legal system is designed to produce sort of winners and losers, right? But is there a win-win scenario, right? One that both protects authors' rights and fosters innovation at the kind of scale that the for-profit and non-for-profit AI providers have been accomplishing in the last couple of years.
Yep, thanks, Chris. So that's actually a really good question. We are not, winning for us does not mean destroying AI. That's not something that we are interested in. I think and in some days it seems hard to even imagine what winning looks like, given the kind of insurmountable disruptions at times that we're seeing. But we do have some very strong notions as to how we can come out of this while preserving, not just the writing profession, but this really special kind of place for human creativity. It really does come down to licensing. I think, as long as AI companies and developers are being ethical and legal, really, about their acquisition of the works that they're trained on, then we can start sort of moving towards a responsible future for the development of generative AI. But if you're, if the developers are going out there and downloading caches of books from pirate sites, then we're already sort of starting off from a very wrong point of view.
In one of the documents from the Authors Guild, it has this sort of three-part principle of consent, credit, and compensation. So maybe just talk a little bit more about that.
Yeah, absolutely. So, the consent is a way to sort of reinforce the idea that authors can you guys hear me? Okay, yeah. Consent is just to reinforce the idea that authors and creators have the exclusive right. They deserve this limited monopoly that's in the Constitution, because that's what they rely on to make a living. And their works should not be used without consent. So, it's another way to say, we need licensing, because in a licensing, what's going on is that the author is saying, yes, I will allow you to use my work for AI training. And I think there is a lot of interest, among authors to sort of allow their works to be used for training. And other authors who are, principally against AI can say, I do not consent to you using my works for training. I also want to make a quick distinction, because, especially early on in the conversations around generative AI, when authors and other creators started talking about, well, where's our right to consent? You guys are just, taking everything that we've created and putting it in. Some of the AI and proponents of AI and AI developers would come out and say, hey, we actually cannot apportion consent, because we're taking, this huge, masses of data. We're just scrapping, we're using scrapes of several tens of billions of websites. We cannot do that. And there needs to be a distinction made between professional human creators and their lives versus anything that's on Reddit or a message board, I think. And you can actually make that distinction also from a copyright frame, because, as we talked about fair use, one of the factors is the impact on the market or the potential market for the work. Now, as far as I understand, there's not a big market for Reddit posts, so I don't know, there might be. But that's one of the ways to differentiate professional creators. Professional creators rely on established copyright markets to earn a living, to raise families, to do, all of the things that we do. Our members, unfortunately, they're not, the earnings just, every time we do an income survey, the earnings just keep going down. According to our last survey, the median income for a full-time author, which is someone that's devoted entirely to their writing career and not doing anything else, was $20,000 a year. And only $10,000 of those dollars actually came from selling books. So, it was already a precarious situation that got even more precarious as we started dealing with AI. I don't know if I answered that question.
Yeah, no, absolutely. And I think, part of what I think people thinking about these issues is trying to find that path to a win-win situation.
Yeah.
Right. That fosters innovation and creativity, and protects creators. And I think that's an ultimate challenge. Yeah. Let me ask a second question, which is a broader one, maybe even a little bit autobiographical for you. You're not a large language model developer, right? You're not a computer scientist, right? And so, what's it like to work at this intersection of technology and policy? how do we ensure that policymakers, policy advocates like you have the best technological expertise? Like, how do you, how do you sort of come upon the technological knowledge that you need to do your legal and policy advocacy work, and vice versa? How would you advocate that technologists get their hands on policy questions and the policy implications of their work?
Again, thanks. That's also such a great question, and I thought about this one quite a bit because when you just kind of dive into the work, you kind of forget how you're working or why you're doing what you're doing, and in sort of thinking about this question, I found it really thrilling because I remember like early days when we were talking about like what it means for law and what it means for policies, that no one really had any, everyone just had these kind of rough metaphors for what was going on, at least on the law and policy side of things. People might say the AI, the machine is eating up stuff, or, it's like, or like it's hoovering up stuff and regurgitating it. And to me, because no one really knew what was going on under the hood technologically, I think the lawyers did not have that facility. So even if you see the initial complaints that were filed in some of the lawsuits, not in our lawsuit, but in some of the other lawsuits against OpenAI and Meta, the complaints were very rough, and it wasn't quite clear what the allegations were, and that's partly because the translation hadn't happened. I as someone who in my copious spare time, I try to translate. I think that a lot of it is translating what the technologists are telling us about what they're doing into a language that is that lay people that are not technologists can understand, and then being able to put it in a thoughtful kind of policy framework. Because as long as there's no translation happening, then you might have policy frameworks that are anti-innovation, or they might be too strict, or they might be too lax, because there's a fundamental misunderstanding of what is going on. So for me, it was really vital that I actually went and I just have such a congenital non-STEM brain. I can't remember the last time I took a math class, but I forced myself to read the CS papers about LLM development and AI in general, like going back to the first. It was I think it's Kiros et al. I don't remember but it was an experiment to match screen caps, movie screen caps with descriptions, and that was one of the first large language model experiments that was used. It used about a cache of 11,000 unpublished books, and to me that was fascinating to see how the technologists were approaching, what they were doing, to as a writer, to see them kind of hearing, just to read them talking about how important books were, or fictions in particular was, in reifying certain concepts. And so so that's how I think it's really vital. I think for my advice to technologists would be, it's hard when you're in your narrow channel of work. Like, it's the same in law, right? When we're doing law, we're just like, there's like an internal kind of grammar that we use. There's an internal language. We don't think about what's going on outside of it. But I think what's important are these cross-functional dialogues. So what people, so you might not go out and say, download 11,000 books for your experiment. You might, seek out a license, or you might actually seek out people who can help you seek out those licenses. It's also just a risk mitigation, especially now, you might face the risk of lawsuits, etc. But it's just good to be mindful of what's going on outside of your box, I guess.
All right, yeah, and I think you're right. I think both that the hesitation that technologists may have about understanding copyright law is as high as what copyright lawyers have.
Absolutely.
About how large language models work. They're both very daunting learning
Absolutely.
tasks. All right. Well, let's take turn gears here and open things up for Q&A. Maybe Casper, if you can kick it off. If you speak loudly, I might repeat your question into the microphone.
I have a question about what the practical threat. Actually,
If you don't mind.
I guess I have a question about what the additional threat to the publishing industry posed by AI and large language models is beyond the internet. So for example, I can imagine a scenario in which you've written a novel, and I say, I ask ChatGPT to give me a word-for-word quote of the whole novel, and it comes back with a 150,000 word answer, and then I read that instead of buying the book. And then imagine that lots of people do this. So we have all the people who would otherwise have bought the book are in fact just getting ChatGPT to effectively give them the book. But that's not happening yet, and presumably it's a pretty remote possibility. So is it that you're worried that that may happen, or is it something else? Is it something short of that that you feel like poses a threat to the publishing industry?
Yeah, that's a really good question too. I mean, you're right that that's a remote possibility. It could be. There was a computer scientist at the University of Chicago, Ben Zhao, I think it's his name, but he was able to get ChatGPT to like give him each successive line from Harry Potter, and he kept going on. So, but then OpenAI put in filters that now the response is due to copyright restrictions, we can't do that. So, so that's not actually the threat. I think that the ultimate threat is devaluing human authorship. When you have, so I'll give you examples of what we see that we are concerned about. One thing is, especially with the internet, a lot of the publishing industry and how people read has moved to, it's sort of controlled by a few big, oligopoly. Anyway, I'm not going to say that word, but like Amazon. Amazon controls so much of distribution and consumption of books, and they thrive on volume. So self-publishing is a huge thing. Now, what happens with AI is that it's so easy to write a book, or like put a book on Amazon and kind of game their system to like earn revenue. So we see examples of this all the time. One of the examples that we've seen is someone will take someone else's memoir and run it through AI and create an unauthorized biography based on the memoir. And it's shorter, it's more consumable. You might be like, I don't really want to read the memoir, I'm going to go for this. That's one of the threats that we see, but like just on a much bigger scale, where AI generated books will just will essentially replace human authored works, which take much longer to write. And then there's kind of this like scenario where people get even more acclimated to sort of like thinking of books as this like there might not even be a human author in question. People are just consuming text. And so for us, like as a advocacy organization for authors, it's very important to make sure that those economic channels remain viable for use by human authors. I don't know if that was a very good question. I don't think if that's a good enough answer, but ultimately, like we are, in infringement, it's the second thing that I do want to mention is that it's not necessarily about the harm of a chatbot reproducing your entire novel, but the harm to the principle of copyright. The idea of consent. That's ultimately what we're trying to vindicate, both through the lawsuits and through our advocacy.
I might add another perspective of this from many sort of academic authors for whom compensation is minimal or sometimes non-existent. Are those other two letters, the consent and credit, right? And So there are many academic authors who right now would recognize, yes, people in the world are turning to commercial generative AI tools to ask and answer questions about how the world works, right? And we have an interest as scientists or others in making sure that the outputs are, have good science in them. Right? In some ways, they want to be in the model, right? But they operated under a previous sort of publishing regime in which they put the articles in, PubMed, or they put them in, publish them under an open license. And suddenly that lends itself to ingestion without the kind of consent and credit issues. Even if compensation may be more of mind for professional authors, but for academic authors, those other two C's can be really important as well.
That's really good, and maybe because you're involved in the open source aspect of things. I was really interested in the new preference signaling methodology that Creative Commons put out. I mean, I think so. For instance, even if you publish something under an open source license, you might not have given a license for it to be ingested for AI. In which case, the consent thing still comes into place. But yeah, now we're moving towards a more robust, so to speak, like. Yeah,
I think that's where I think the authors and scientists, inventors, other kinds of people will ultimately need to be heading.
Yeah, and again, like going back to the market part, right? I mean, the market for academic work is very different than the market for a trade book or for a romance novel, or a detective story.
I have a very basic question, so forgive me. It seems to me that a lot of what makes copyright enforceable is whether or not someone is infringing on the market value, the ability to make money, and people's ability to fight being unfairly ingested without their consent seems to be increased if there is an organization that they work for, like the New York Times, that can say, hey, you are impeding on my future profits. Whereas individuals like screenwriters, right, if their subtitles are uploaded into an open database and that gets ingested, it's harder to make that argument that a screenwriter, that you're hurting their future proceeds because they're not part of this larger organization. So my bigger question is, what are the failings of the copyright law as it is currently written? And because so much of it seems to be framed in terms of making money, what is that leaving out?
I mean, just so many amazing questions. I should have known I'm at MIT. So a couple of comments on that, actually. It is interesting. You would think that working for an organization like the New York Times as a writer would kind of give you a little bit more, would give you leverage for enforcing your rights. But what happens is that, when you're a staff writer for the New York Times, the entire copyright belongs to the New York Times. So, or even if you're a contributor, a lot of times the New York Times will take all rights in the work, which means that you actually don't have any rights left to enforce. So all of the enforcement that is going on from a copyright point of view is New York Times kind of enforcing its own property interest in things that like authors have written. So, but it is a very good question because with screenwriters, for instance, there are unions. Now, unions are playing a very important and interesting role right now because one of the threats to the profession comes from, say, studios not hiring screenwriters, but using AI. And last year, there were some very intense negotiations between SAG-AFTRA because it's also affecting actors. I've heard like just very strange stories of like if you have a tiny role for like $50 a day, you show up on set, someone takes you aside, gets you to step in like a booth, and they do a 3D print scan of your body, and then that's used for like so there are things like that are happening. So unions are playing a very important role right now in enforcing rights. The difference between us and a union is that unions, unions also, like the way entertainment unions work, and this is just by way of background in case you're interested. I'm going to get to your ultimate question. The way the unions exist in the entertainment industry, we're not a union, but in screenwriting and acting, they exist because there is an arrangement between studios and the talent that that the talent is actually considered an employee of the production, which is why they're able to get health insurance and residuals. So it fundamentally always comes down to health insurance. Unfortunately, So even in that case, the screenwriters don't actually have any copyright in the work because they are considered employees of the studio for that. But because they have the union, they can push back against the, but they don't have the same rights vis-a-vis AI companies. Now, copyright law, a lot of it is about making money because copyright, but it's about making money, but there are other parts to copyright law that I'll mention. It's a really good question, actually. It's for our members, they pretty much only rely on copyright because they're trade book authors. Their books, the way they're sold is that a publisher is interested in a book. There's there could be an auction for the rights. The publisher then repackages those rights and sells it to a film company if it's a big book. So it's the value is at every stage of the supply chain for those rights has a value to that. So it's all driven by copyright for our members. The other things that copyright really, it's been called the engine of free expression by the Supreme Court. And it's not something that we really focused on today, but, I think that with how easy it is to kind of generate misinformation using AI, and it's that signal noise kind of question that comes up. Like the signal gets buried when there's too much noise, which is one of the reasons why we need to sort of have regulations around what is AI generated, what the consumers are encountering. The copyright also leaves out other areas, because copyright is limited to the protection of expression. Copyright does not protect ideas. So there's very oftentimes authors will come to me and they'll say, someone plagiarized my work. And I'm just like, well, did they actually copy your expression? And they'll say, no, but they took my idea. Well, that's not really actionable copyright. So, but there are these other attributes of the work, like an author's voice, for instance. We're seeing this now in analogous areas. Like voice actors, for instance, have been able to make a really good case for they call it biometric ownership of their voice attributes. But authors have an authorial voice, like Hemingway has a very recognizable voice. That's not really protected by copyright, So there are things like that ideas are not protected. If you have a very unique idea for something, that's not really protected by copyright. So there's still things that fall kind of out of the copyright sieve, so to speak.
Yeah, thank you.
First of all, thank you very much for the talks and also the discussions. Really, I feel it's very insightful and meaningful to all of us. The question I have, actually, we had a chance to briefly talk about this before the session, but I think it probably will benefit everybody in the audience, is that in MIT you have many events like this, and it's usually recorded. And usually when you record this, and if you put this on website, we ask speakers sign consent. So that's the normal situation, a process everybody is familiar with. But with generative AI, you can add some generate more valuable results from it. Basically, you can easily summarize a person's presentation or panel discussion and generate that into a summary. And I know you told me you need to separate the resent form for that report and signed by all the speakers or participants. I wonder if you can, Ume, you can describe a little more detail
Sure.
how we should approach this. Or
Sure.
can they sign the same, two items in the same consent?
Sure, absolutely.
With video recording or the rest?
Yeah.
I know what kind of potential risks there could be if we don't do this properly? Thank you.
Sure, absolutely, absolutely. So you're looking at a few different things. One is the actual copyright, right? So if I come, if for instance I came here with a speech that I had written, and I go to the podium and I read that speech, and you recorded that speech, I have a copyright interest in that recording because that is a recording of my, expression. So when you do a release form, a lot of times, like the release form will contain an intellectual property release where you say, I actually give you permission to use any intellectual property that might have come out of my talk in a way that you want to. And if you have that intellectual property release, then you're fine. Then you can run it in in an AI because you have a broad release. I guess it comes down to how broad or narrow the language of your release is. And then the second thing that you're looking at is also rights of publicity and personality, especially if you have a celebrity. Celebrities oftentimes have what are called rights of publicity, where they own almost like a trademark type interest in the way they look or their particular style. So you want to make sure that your release contains, that they allow you to use it in that way.
I'm sit here and listen to, and I substitute write a kind of like a understanding or summary about what I learned. And do I need to get permission from you?
No, not in that, not as an audience. No.
Okay, got you. Thank you.
All right, thank you. My question is about, is there a difference between potential infringement versus actual instantiated infringement? Because
No.
Right,
There's no
just having the model itself, but not using it to do X versus the actual X. Just wanted to get a better understanding of that. Thank you.
Absolutely. No, there is no such thing as like infringement in the future. The infringement either occurs or not. Now, but you raise a very interesting point, because infringement, when in the context of AI, happens, the way I understand it, the way I explain it, it happens it can happen at two different stages, right? So you have a model, but you're not prompting it to do anything infringing. So you're not committing any infringement. However, when the model was trained, there were copies made of works during the training process, and the algorithm was run on. So there is infringement that has already occurred at that point. Now, as a user, it doesn't concern you, but I just wanted to be clear. We say infringement in the output versus infringement in the input.
So let me take a kind of devil's advocate position here, right? Which I think we have heard from some of the large language model developers, right? And the story goes something like this: if I walk into a library, if I go into a library and I read every book on the shelf, and I walk out and I write the great American novel, I don't know anything to the people in the library, right? Is that what large language models are, or what's different? Setting aside the specific case of when we know that they are trained on specifically pirated information, right? But is that specifically the issue?
Yeah, so that's so my kind of I get asked this question a lot, and my usual flippant answer is like, are you worth 1.3 trillion dollars? Because that's what that's what the value of a sort of a technology like that is. But I mean, it is a very good question, because there are two things that I want to say about that. One is, goes back to your earlier question about translating sort of between technology and policy and language, how important language is. So, a lot of the language that we use around AI has come from people that have a very large commercial interest in AI. So, the reading analogy is done precisely in some ways. It does obfuscate what happens in a kind of at the technical level when you train a large language model, which, as I've said a few times, it actually makes a copy. Even the probabilistic representation in the model is a representation of that expression. Now, you can make that argument, well, when you're reading something or memorizing something, your brain is doing the same thing, and is that like copyright infringement because your brain is doing that? I mean, this can get philosophical. I guess my brain is a tangible medium of expression. to use the definition. But the short answer is that the difference is between scale. It's like and copyright fosters, like, it also goes back to this idea of human authorship. So copyright is precisely interested in humans innovating, based on the work of other humans. But copyright is not going to protect like a mechanical or like an algorithmic like process that can be used on a very massive scale, to do the same thing.
Okay. Maybe we'll have one more question. Casper?
I would just be curious about what your idea about the long-term future would be. Suppose in 15 years' time.
Yeah.
How would you hope that, what sort of arrangement between authors and AI companies would you like to be in place? Can I just give a tangible example? Yeah. Suppose I wrote Harry Potter books. Suppose I license, I say it's okay for AI to be, large language models to like take my books and read my books. Is it that I get paid a flat fee for that? Or is it that when the AI is then used to generate a fantasy children's book, I get some portion?
Yeah.
But how would that work? Yeah. Because how would you be able to trace like how big an influence my books were on the output versus other books that it may have read? Yeah. Like, so how are you thinking? I mean, I've got a clear sense of like, you don't want them to be trained on pirated versions of my books now, but what is the 15-year good solution that we could find to this?
That's we've spent months talking about this. It is like believe it or not, like it is the, as they say, the $1 million question in all of the specialized copyright law panels that I've attended in the last few months. Licensing. So one thing that I will say is that licensing is already kind of mushrooming, because I think the presence of large language models created a need, and then there were tons and tons of startups that are like filling that need right now. So almost on like a semi-weekly basis, I get an email from a startup saying, hey, we're building like a licensing model for like content. Are you guys interested in talking to us? The Authors Guild actually has one partnership right now, and we will have other partnerships, non-exclusive partnership with a company called Created by Humans, which facilitates licensing to AI companies. So 15 years down the line, it might happen like in the next year that like we have all AI uses are sort of licensed. Now, the question that you ask is a very interesting one, because the value of the market has not been established yet. So, the few examples that we have seen, so for instance, HarperCollins, the big publisher, they entered into an AI licensing deal, and they set the value of each work at $5,000 for a 3-year license. Lump sum. The work can be prompted as many times, used as many times. So that's one way people are looking at it. Do we go for a lump sum? There are technological ways that I understand are, I'm at MIT, so someone here should tell me if this is true or not. But there are the technological means that are coming around where you can kind of calculate a base value for how many tokens were used, and align it to the particular work. So it's not even that like, someone generating a fantasy novel. It's like whether or not Harry Potter, the token attributed to Harry Potter in the large language model were used in generating a response about wizardry, for instance. So those things are coming, but I imagine that the income from that is going to be minimal. Now, we're also seeing all kinds of interesting downstream uses starting to come online, like chat bots based on authors. One of the things that early on came online was something called the Dan Brown chat bot, where you can kind of talk to Dan Brown about his books, and it was basically they had ingested the books. But the licensing question is a very interesting one for me, because I'm in like in discussions around that a lot. Right now, people are starting with lump sum, but I think there's going to be a finer economic value that we will eventually ascertain for these rights.
All right, and I'll just say one final thing, that long term in the field of generative AI is 15 months. but we do need to be thinking about 15 years.
DeepSeek came online, so now we don't.
Yeah. So right now we're going to take a brief break, and there may still be some snacks outside, restrooms down the hall, and our Umair will be in attendance at the next panel. Our next speaker will come in a few minutes after that, and we'll start up again soon. So thanks very much.